One of the hardest things that I've ever done as an estate planning lawyer is to prepare wills for a mum and dad that have a vulnerable child. There are certain protections that can be put in a will to protect a vulnerable child, and we're going to go through those forms of protection today. My name's Professor Brett Davies. I'm a barrister and solicitor of the High Court of Australia. The will comes into effect when you are dead, and that's problematic because whatever you're doing now, you can't sort of argue the toss after you're dead. So everything needs to be put in the will. The divorce protection trust, the bankruptcy trust, the protection trusts need to all go in the will while you're drafting it, while you're still alive. I would now like to start building the will and just taking you through a few of those things that you need to consider as a parent. So our website, we're a law firm, we're an Australian law firm, and you can build your wills on our law firm's website. And today we're going to build mutual wills, dad to mum, mum to dad, everything to the children equally. You can read all the hints, the 32% tax you've got to pay, or the adult children have to pay on their super, unless you've got a superannuation testamentary trust in the will, the divorce protection trusts, how to make sure that your children don't lose it, their wealth. There's also a full sample with all our documents, starting with a covering letter. So you'll always get a covering letter with every document we ever build on our website. There's a checklist of the questions that will be asked. But let's dive in. I'm going to press the big green button, start building. So this is preparing my mutual wills, my mirror wills. They are 3-generation testamentary trust wills, which means there's a vast array of protection for children that may lack the capacity to look after wealth. I could pick up data from a previous will, but I'm going to start, or from a previous document, I'm going to start afresh. So I'm looking at mum and dad's name. I'm going to put in the spouse's name, in which case is my wife's name. Now you see on the right, there are a number of hints. So is my data saved when I press next? So if I press next, is my data saved? Yes, it is. And I've got a green tick. The logic flow in our wills are very tight, all our legal documents, because our law firm is responsible for the documents. Now, let's start with the mutual will. You've left everything to dad, and mum's left everything to dad, and dad's left everything to mum. They're each other's executors, but now what? So let's say you've got 3 children. One of the child is vulnerable. Well, what does that mean? Well, one of my children is unable to look after money because she lacks mental capacity to do so. And she has never going to have the ability to look after wealth. So in this instance, we're going to not make that child an executor. We're going to make the other 2 children the executors, and they will look after the wealth for that vulnerable child that can never look after the money. So I'm going to leave the age of majority at 18, but in the residuary beneficiary clause, I'm going to put in, let's say the vulnerable child is the oldest child, and for political reasons. For political reasons, you generally put your children in age order, so the oldest is first, down to the youngest. In this case, my vulnerable daughter is the oldest child. Now what I'm going to do here, I'm going to still leave her 33 1/3%. But, and this is important, I'm going to make that age of majority 99 years of age. So my daughter that cannot look after money will not be able to touch that money until she's 99 years of age, in effect can't touch the money at all. In that time, It will be in a protective trust automatically because the age of majority is 99 years of age. And it means that the two executors, your other two children, will look after the money. What's that? You don't want your other two children, to be burdened with looking after the money. Well, that's problematic because you need someone to look after the money. What's that? Your two children are not that bright with money and you feel they won't invest it properly. That's not the test for an executor. The test for an executor is, do your two children love your vulnerable daughter? That's the test. You can get advice from a financial advisor, accountants to do tax returns, real estate agents to sell property, lawyers to get probate. That's not a difficult thing to do. You don't have to be smart to be an executor. You don't have to be smart with being an executor. You don't have to be smart with money. You have to love that person, that vulnerable person. And the closest relatives after you and your spouse are dead are those two children in this instance, and they're your prime candidates. If you don't want that, you can pick other people, nephews, nieces, uncles and aunts, but you want to pick people that are of young age, because it's going to be a long time before you and your spouse die, and your daughter's going to live hopefully for a long time after that. Therefore, you want executors that will last the distance. If an executor does die, then their executor takes over. So there's a succession planning with the role of the executor. If you don't like that, you can always get a professional executor to be executor. I do not recommend it. I do not recommend the public trustee. I don't recommend lawyers. I'm a lawyer myself, but I don't recommend a lawyer be the person looking after the money, or an accountant, or a financial advisor, or perpetual trustees, or one of the professional trustee companies. I don't recommend it. I think you should have someone that loves your child. I think they're better. If your two executors need help, they can go to a professional trustee company and get advice. They can go to a lawyer. I would caution you not to use professional people. They just charge money, and I don't necessarily think they are understanding of the needs of that vulnerable child. So in this instance, I've dialed up the age to 99. With the other two children, I'm going to leave them a third each, but their age of majority I'll just leave blank. It'll be just 18. You don't want 18, you want 21? We'll make it 21 if you want. So let's have a look at these hints over here. How do the children split up the assets? And there's yet another training video. So you can see that these hints here help and guide you on how to answer each question. Now, you want the family home to go to your vulnerable child. That's what you'd like. Don't do that. Don't do that. You face three great uncertainties. You don't know the date of your death. You don't know what the tax laws will be, what will Centrelink be doing, what a special disability trust, all these things are in the will, but you don't know what the laws will be and the taxation system. And you don't know what assets you own. I know you think you're going to own those shares of BHP because you've owned them all for 30 years. I know you think you're going to own that family home forever and that block of flats in Double Bay, or whatever you think you've got. It may not be the case you own those assets at the date of death, and you should not leave specific gifts. So you can leave specific gifts. There's a specific gift clause. So you could leave the family home to that vulnerable child. It's best not to. It's best not to. So here's a specific gift clause that you can put in your will. You can put a right to reside. So there's a hint on a right to reside or a life estate for the family home. I caution you, have a read of those hints. I caution you not to do that. It's better to leave everything a third, and let the assets be used and manipulated, given the best tax position, and also for Centrelink benefits for that vulnerable child.
Don't leave life estates, don't leave specific gifts. It's not good advice to do that, because it's highly likely you will not own that family home by the time you're dead. You get dementia at 99 years of age, the children use your power of attorney to sell that family home because it's now subject to capital gains tax or land tax. It's sold, other things are bought, you get a balance share portfolio with a financial advisor, and they do something else. You don't know what assets you own. That's one of the great uncertainties. If you have to narrow estate planning down to one word, it's flexibility, because you don't know those three things. You don't know when you're going to die, you don't know what assets you're going to own, you don't know what the tax laws will be. You could do a specific gift. I caution you not to. Just leave everything a third, a third, a third. Unborn children. That tells you how to put unborn children in your will. Child mentally challenged. So here you'll get more information about a vulnerable child. Now, in this instance, the child never has the ability to look after wealth, and the two remaining executors, or the two executors being the other two children, in that instance. And telephone us, please. Telephone the law firm for free advice in building this document, and speak to me personally. But there may be other times where the vulnerable child is perhaps in the future able to look after wealth. We had a client recently where there were two children. One of the child was an alcoholic. And so mum and dad in this instance dialed up the age of majority to 99 years of age. But by the time that the parents had died, the child was no longer an alcoholic. And the fact the person that was previously an alcoholic had a family and what have you, and in that instance, the remaining executor released the money to the now no longer alcoholic son. So there's a lot of flexibility there to deal with situations. Another case we had was where the child was just a skibbity gibbet, just hopeless with money at 17, 18 years of age, but the parents felt by 35 years of age, the child would have mental capacity to deal with the will. They felt that the child would have it, so it would have the knowledge to do that. So in that instance, you would have made the age of majority not 99 years of age. You would have made it not 99 years of age, but say 35 years of age. So you can change the age of majority as you see fit. Now, another advantage of building your three-generation testament trust wills on our website is you can update them for free. So if you build a will today for you and your wife, all powers of attorneys or medical or lifestyle powers of attorneys, which you can do for each state of Australia, you can update them as often as you want for free. So if circumstances change with the children, you can go back in and you can change the age of majority to an older or younger age. So, child's a bit of a spendthrift. Child can't handle money. Too immature, suffers from mental illness, alcoholic or drug affected. You can set the age majority as you see fit in order to protect that child. During the time that they're under the age of majority, so let's say you've made 35 years of age, the age of majority, while the child is 25, 30, 31, 32, the money is controlled and looked after by the executors. Now, in this instance, the flippity gibbet, I'm not sure that's a real word, but the child that is not able to look after the wealth can still be one of the executors. So let's have a look at that situation. So we've got here the backup executors after mum and dad are dead are, let's say it's the child that's immature, but you still make them executors at 18 years of age. What's that, Professor Davies? The child's vulnerable. Why would you make them executors under the age of 35? As a parent, I've decided that 35's the age the child gets the money. Why would I make them executors at a younger age? Well, this is the reason why. You want that child to become involved in the investments and the looking after and the tax returns and the land tax and stamp duty on transfers and buying and selling shares and all those other things that the financial advisor will help you with. So in that instance, you might have, say, 3 executors. Either 2 children are the executors and the third vulnerable child is also the executors, all at minimum age of 18. The executors have to act unanimously. No. They have to act. They have to act unanimously. So you can't have the one child, vulnerable child, taking the money. All three have to agree to take the money. Now, for the two other children, their age of majority may have been 18 or 21. They've got their money and they've gone. They went many years ago. But the child, while they're waiting for that child to turn 35 years of age, the three of them, the three executors, including the vulnerable child, is involved with the looking after the money. Now, this pays a lot of dividends because it's when the child eventually turns 35, and I'm just mentioning 35 at random, you could make it 45. My father says you don't reach maturity till you're 60 years of age, but now I'm 60. He feels it's probably 70 before a man reaches maturity. So beauty's in the eye of the beholder. You want to have all children's executors in this instance because you want the three children, including the vulnerable child, to be emotionally charged with looking after the money. So when that child eventually turns 35 years of age, when the child eventually turns 35 years of age, it's not just a windfall amount of money they're being given. They've been looking after that money. They know that the share portfolio, the interest that's being charged on the money, all the properties are being owned and sold, and how expensive it is to get into properties, to get out of properties, how the land tax systems work in each state. So for that reason, if the child at some point will get hold of the money, you should make them the executors or consider making them executors. What's that? The three children may fight. They hate each other. Let me be very clear here. You have a misunderstanding of the role of executor. The beneficiaries are in charge, not the executors. The executors are squashed cabbage leaves. They must do the bidding of the beneficiaries. Once the beneficiary turns 35, the beneficiary is in control. That vulnerable child can take the money. If the children are going to fight, then it's better that all three of them be the executors. If the children are not going to fight and all love each other, it's still better that all three of them be executors. Let them fight at the executor level. Now you notice that I'm getting ticks for my questions. You will not see the lock and build button until you see ticks for all the questions. So residuary beneficiaries will put in their three children, 1/3 each. Now disaster clauses only if you've got unborn children or children under that travel with you. So they're still 15, 16 years of age. Once the children aren't travelling with you, you don't need a disaster clause. The disaster clause is there if you're in the car and the car all rolls over together or the aeroplane crashes and you, your spouse and your three babies all die at the same time. That's when you need the disaster clause. Only then would you want to put one in. You could put one in, but you won't need it because unless you're in some sort of nuclear holocaust country, you're not all going to die at the same time. But if your children are travelling with you, they're still young, then you would put that in. You'd leave 50% to your side of the family and 50% to your spouse's side of the family. Contemplation of marriage, 99% of people will say no to both of these questions. But if you're not yet married, you've been living with the person for many years and you're not in that spirit of getting married, that's not who you are, you still press yes because you may have this romantic holiday in the Barossa or in Broome or in Burnie in Tasmania or some romantic spot. I don't know if Burnie's that romantic, but beautiful property there. You go there and you suddenly get married, your will's invalid, so you want to put contemplation of marriage. So if you've been with this person for a long period of time, you're leaving everything to each other, and you're not yet married, still put in the contemplation of marriage. Same-sex marriage is allowed, so just press yes if you are in a de facto relationship and you are leaving everything to each other. So let me just repeat that again. If you're in a de facto relationship, you're not yet married, one, so you're in a de facto relationship, you're not yet married, and you've left everything to each other, then you should put a contemplation of marriage clause in. Because if you do get married, I know you're not going to get married, but if you do get married, your will still remains valid. Contemplation of divorce, almost 99.9% of people will say no to this, no to these questions. It's just if you were married many years ago and you can no longer find you haven't seen your old husband or wife for many years, and you've gone on with your life. You want to press yes and put their name in. If you're in the process of getting a divorce right now, you wouldn't be doing a mutual will, leaving everything to each other. You'd be doing a single three-generational testament trust will, in which case you press yes, this will is in contemplation of my separation or divorce of whoever you're separating from. So when you do get the divorce, your will remains valid. Now you have to do that. As soon as you catch your spouse cheating on you, you go straight in, you redo your will for free, and you make sure you press yes to that button and say this will's valid if and when I get divorced. Because if you now wait the 1 or 2 years for the divorce and you die, then your spouse, your cheating, lying spouse will get everything, which you don't want. You want everything to flick off your ex-partner and go to your children. Guardians, that's if you have children under 18 years of age. Someone that will challenge the will. If you are leaving a third to the vulnerable child, you do not need to put in that child to challenge the will. It's not required. But there's plenty of hints about who can challenge the will and what have you. And again, if you need a hand, just telephone us for free legal advice to help you build this document. Reference, that's just more for financial advisors, accountants and lawyers that are using our website. If you want the business logo on, a lot of financial advisors, accountants and lawyers will want their logo with the document. Remove Legal Consolidated's logo. You don't want to do that unless you're a lawyer yourself. You can press to have this document printed and bound, and you can also have a lawyer telephone you if you wish. You now press lock and build. Once you've answered all the questions to our satisfaction, once you have satisfied our logic flow and you have green ticks next to each question, only then do you see the lock and build button. Now, on the summary page, you can actually see how you've answered the information. And this information is stored forever. So you can come back in 10 years' time, this information will be there. You can always redo your will based on the old information and change it as you see fit. Save you having to re-type it in, or you may want to do a power of attorney or commercial lease or whatever you want to do. So there it is. There's all the questions. And if you've made a spelling mistake somewhere, just go back in, clean up that spelling mistake. So now I'm going to press lock and build. Here it is, lock and build. I'm going to put my credit card details in. So I have now built my documents being emailed to me. It's also stored on the law firm's website forever. You can go back in any time. The document is available for me to now look at. It's a locked PDF, which you print out. You'll have the covering letter and how to sign the will. Professor Davies, I can't deal with a locked PDF. I like fiddling with things. I like changing documents. Well, I'm sorry, that's not the business. We are a law firm responsible for this document. You cannot change it. You can redo the document for free, but you can't change that locked PDF because it's prepared by our law firm to be operational as a three-generation testamentary trust will with all the tax-effective documents to wash out the 32% tax on your superannuation when you die. It's got the vulnerable children protective trust, which we'll see in a minute. It's got the disability trusts and things. They're very carefully crafted into the will. You cannot change it. So all documents are stored, and there is the locked PDF, Mutual Wills Tax Effective. So this contains a three-generational testamentary trust, which contains everything you need to protect this vulnerable child. So I'm going to open it up, and let's have a look. So firstly, you'll note that the covering letter is on our law firm's letterhead, confirming that you have instructed us as the client, you've instructed us to prepare this will. How to sign it, the signing process, so find two people over 18 years of age, of sound mind. There's also advice if you're in isolation, you can sign it. There's procedures on how to do that. And telephone us again anytime. You sign with a blue pen. Your two witnesses in the room all can see you. All the beneficiaries leave the room, so it's just you and your spouse and the two witnesses. There's the advice on superannuation, of what we believe you should do. We believe that you should leave your super into the will so we can wash out the 17 or 32% tax. The covering letter, a doctor's note. You must get a doctor's note to say you are of sound mind and able to make a will. We've given you the wording to use, but I think since 1988 I've never found a doctor to actually use the wording that our law firms provided, but there it is if the doctor would like to use it. Otherwise, whatever wording the doctor uses is fine by our law firm. In the will, you'll find a 3-generational testamentary trust, which reduces the capital gains tax, the stamp duty and income tax. The superannuation testamentary trust to try and wash out that 15 or 30% plus Medicare tax on your super. The protective trust is very important here because we've dialed up the age of majority to 99 years of age for the child. And bankruptcy trust in case a child or grandchild or beneficiary. So this is on the expectation that you're leaving to children. Obviously, if you're leaving it to nephews, nieces or whatever, whoever the beneficiaries are, they get all this protection. Divorce Protection Trust is in case a beneficiary ever gets divorced, or if it's a child, then a child. If it's a grandchild, then it's a grandchild. It works for up to 80 years from date of death, and in South Australia it works indefinitely. Special Disability Trusts are automatically put in all our 3-generational testamentary trust wills, not whether you've got a vulnerable child or not. They're always in there because it could be the case that your child wasn't vulnerable when you made your will, but the time you die, the child has had a heart attack and can't function, or it's had a car accident, or something's happened to the child. So there's protection in there, even if you haven't increased the age of majority from 1821 to 35 or 99 years of age. How to bind the will. Staples are fine, but don't unstaple the will once you staple it. Don't print the will in duplex or back to back. Just print the will single-sided. And here's the will, the last will and testament. So in this instance, we're leaving everything to the spouse. And after that, well, in this case, I haven't put it in, but it goes to all 3 children if you had to put the 3 children in, or just put the 2 in if you've dialed up the age of majority to 99 years of age. So the age of majority is there, the maintenance trust. So this is very important. Clause 8, and your will could be different depending on how you draft it. So Clause 8 in this sample that I've just built. Where a primary beneficiary is under the age of majority. Now that's the case if you've dialed up the age of majority to say 99 years of age. In that case, the child or beneficiary cannot touch the money. But the money is still available for maintenance, education, advancement, support and benefit of that primary beneficiary. Now this is Centrelink benefits. This is able to take what money is necessary. So if that vulnerable child needs medical treatment in, say, Stanford University in America, and you've got to fly in a private jet, and that costs $1 million American dollars, that money, if provided that there's wealth for that particular child, that can then be used to protect the child. So these maintenance trusts are not just for toilet paper and a Woolworths shop. This could be anything that protects that vulnerable child. Having a minder living in your home. So after you and your spouse die, it may be the will of the executors that the family home, which the vulnerable child knows, the vulnerable child stays there and a minder is hired to look after the child in that family home. It is used there in this instance, 1/3 of the assets are used for that vulnerable child's best interest. It's not locked away. It is used and available for that child.
It just can't be spent by the child. So if the child is a spendthrift, they can't get their hands on the money till they've reached the age of majority. Protects from bankruptcy trusts and divorce as well. If the child lacks mental capacity, automatically they are getting the vulnerability protection as well. If they're an undischarged bankrupt, it means that the child's bankrupt, they're also protected. And if they suffer divorce proceedings, so the Divorce Protection Trust will come in to protect the children. So even though the children have got the money, they're already of age, they're still protected by the Divorce Protection Trust, the undischarged bankrupt, and the requisite mental capacity. The executor's powers in Clause 9, they go on for page after page after page, and they're there to protect the family. Obviously, if you're dialed up that child to 99 years of age, then these powers are restricted for how they can use them. The executors will use them for the vulnerable child or that child's best interests. These are the new tax rules. So the executors have power to establish testamentary trusts or not. It may be a reason for not to establish testamentary trusts. Oh, Professor Davies, my accountant said testamentary trusts always need to be set up because they're always in the best interest of the children. I agree. The 3-generation testamentary trust is wonderful. But laws may change. The will must remain flexible. You don't know when you're going to die. You don't know what assets you're going to have. You don't know what the tax laws are going to be. They're the 3 great uncertainties. The protection is flexibility. And the most flexible document, the most flexible will you can do is the 3-generation testamentary trust. And that's this document we've just built. So I'm looking at page 12 to establish disability trusts, including special disability trusts and special disability trusts that qualified under the Social Security Act. So there is ample protection, ample flexibility for the executors to do what is necessary to protect that vulnerable child. And to vary any trusts, foreign beneficiaries and land tax, it's to look at the additional stamp duty if your child's living in London or one of your beneficiaries living in overseas, to try and reduce the higher rate of land tax and stamp duty. The superannuation testamentary trust designed for only one reason. The only value of Clause 11, the superannuation testamentary trust, is to wash out the taxes on your superannuation at date of death. What's that? Oh, Professor Davies, there's no tax on super. It's a tax haven. That's why we put money into superannuation. It's really good. I know all that. But when you die, that money was for your retirement. You've just died. The money has to be paid out. Your super cannot remain in the superannuation regime. I don't care if you're in a self-managed super fund, an industry fund, a retail fund. It makes no difference. Upon your death, super must be paid out. Unless you've got a reversionary pension, which is something that your financial advisor can give you advice on. But apart from you having a spouse or having a reversionary pension, your super's got to be paid out. And when it's paid out, when it goes to adult children, the tax on it can be up to 30 or even 32%. So up to a third of your super can be lost. That's a very important conversation to have with your accountant and financial advisor, and Clause 11 seeks to reduce that. And there's the husband's will, and there's the wife's will, which is the mirror image of each other. So we have built ourselves a 3-generation testamentary trust. We have gone through those things which are necessary in order to protect the children, vulnerable children in particular. There are many other types of documents that you can be built as well. So let's have a look at them. Obviously, you'll need enduring powers of attorneys and medical powers of attorneys, or as we call them, Victorian medical treatment decision makers. If you've got a self-managed super fund, you'll need a company power of attorney for the company that's running your self-managed super fund. There's the Protecting Vulnerable Children in Training course, which you're watching at the moment.
If you're in a second relationship, so you remarried, you may want to lock these wills in with a contractual will agreement, and this will stop each of you from changing the will. If you're in a first relationship, I don't think you're going to need that, but it's there if you need it. If you are lending money to your spouse, now asset protection is very important. So if your spouse is a business person running a business, the high risk of bankruptcy, so it might be a man of straw, that's the business owner, and the woman of substance, as say the wife that is a primary school teacher, low risk of bankruptcy, then if the money's required, then the woman of substance will lend money to the spouse. With children, you should not gift them money. Do not give them the money, just lend them money. If you need to forgive a debt, particularly in family trusts, unpaid present entitlements, you can do so. If you want to make a deed of gift and want to make it so no one can ever challenge it, you can do a deed of gift. Family trusts are not controlled by a will, but controlled by a deed of change of appointors. Superannuation, binding nominations for super. A reversionary pension kit, that's where if you have a spouse or a younger child or a disabled child, you can potentially keep your money in the super using a reversionary pension. So it's the one exception to the rule that super must be paid out at death. It's a financial planning product, and you should talk to your financial advisor about that. You may want to get rid of some of your old family trusts. If you've got them, you can vest them. Same with the unit trust, the same with the self-managed super fund, and clean up your affairs. If you need help with any of these documents, then you can telephone the law firm. We are an Australian law firm, so when you ring up, you're going to speak to lawyers. Telephone us for help building this and any other legal document. Enjoy the wonderful services this website provides.